Mr. Schumacher, for 1 second, because for some reason...
No, wait a second. I'm done. Next case. And let's go ahead and set forth our appearances for the record.
Your Honor, Will Kemp, Eric Pepperman, Teddy Parker, plaintiffs.
Good morning, Your Honor. Joel Odou on behalf of Will Water Inc., defendant Gallagher, Salzbach, Conning, Will Water, Gold Coast.
Good morning, Your Honor. Scott Rasmussen and Ryan Flanagan on behalf of Hanna Instruments.
Good morning, Your Honor. Elizabeth Lowell from Milwaukee and Rob Robbins coming soon for Milwaukee. Thank you.
And thank you, ma'am.
Good morning, Your Honor. Jim Kavanaugh, Gordon Rees with Robert Schumacher for Real Water of Tennessee, LLC.
All right. And once again, good morning. It's my understanding we have, make sure we have this correct here. Let me go back. And we have plaintiff and defendant United Natural Foods West Inc.'s motion for leave to amend third-party complaint on an order short of time. Okay. Mr. Kemp,
Yes, Your Honor. This is our motion to amend. The primary issue I see appears to be that Real Water's position is that we didn't agree with third phase trial. We filed a motion for the to address this issue, the motion to eliminate, and I thought it was pretty clear in the motion to eliminate that we wanted compensatory phase, punitive phase, and third-party phase. There's discussions on the record about that. Mr. Odou points to discussions the day after. But it's clear as a bell that both Mr. Neal and I were of the opinion that we were going to have a third phase. And the reason I say it's clear is because the day before the trial started, we bargained for the rights here. That's where the motion comes from. It comes from our settlement agreement between the 7 plaintiffs and UNFW, where one of the items of consideration is the right to certain proceeds from this specific policy. So it was clear as a bell that Mr. Neal and I both thought that was the position being taken by everybody. And it wasn't until after that we find that the Real Water's position is that all of a sudden we didn't have a third phase. And so I think the motion to amend is appropriate. I don't think there was any confusion because our motion was pretty clear and I wasn't confused. Maybe Mr. Odou was confused, but that's basically the grounds for the motion. And obviously we're just being added in as nominal plaintiffs. Doesn't change the substantive nature of the action. And so for those reasons, I don't think there's any legitimate grounds to deny the motion to amend.
Yeah, thank you, sir. Mr. Odou.
Good morning, Your Honor. Joel Odou on behalf of Real Water, Gold Coast, and the other Real Water entities. Your Honor, I would point to a couple things, and not to be flippant about it, but just like trial, I don't see Mr. Neal or UNFW here. If we look at the motion in limine that was filed, it was plaintiff's motion in limine number 41. This motion in limine is directed to Real Water Tennessee. That's the title of the motion. Real Water Tennessee is referred to throughout the motion. And as this court's minutes indicate, that motion was withdrawn as moot. So there was no motion as to Real Water Gold Coast, first of all. Second of all, as to Real Water Gold Coast, Mr. Neal and UNFW abandoned that claim. They abandoned that claim for the very simple reason is it has no merit. We have attached relevant portions of the deposition of Brent Jones. Brent Jones testified that Real Water Gold Coast didn't sell water in Nevada. We have the trial testimony of Mr. Haley, who we settled with, and Mr. Belsky, who we didn't settle with, where the words Gold Coast, or for that matter Tennessee, never come out of their mouth. So if UNFW is going to claim that there's some type of genuine issue of material fact that would keep this amendment by them and the plaintiffs from becoming futile, we're unaware of it. Moreover, that fact could have been adjudicated by the jury, as it should have been. Instead, UNFW abandoned that claim. In addition, I would point out that Real Water Gold Coast has been prejudiced by that abandonment, because now apparently we find after the jury has returned a verdict, or at least we found out shortly before the jury returned a verdict, that there's been some kind of assignment. We haven't seen that assignment. We don't know if it's a Mary Carter in violation of Nevada law. We don't know anything about that assignment. All we know is that there was some type of assignment that we only learned of after the evidence was heard by the jury, and that too is prejudicial. We would join in the arguments of Real Water Tennessee. They filed a opposition to this motion last night. We're filing a joinder. It may or may not be on file right now, but we would join in their arguments that they got summary judgment. They have also similar issues and more issues as to why this amendment should not be allowed. And then finally, Your Honor, as you know, we have pending a motion for directed verdict for Real Water Gold Coast in particular, but as Real Water and Affinity as to this purported cross-claim against the Affinity and Real Water Inc. entity, and the third-party claim against Real Water Gold Coast. So for all those reasons, we believe this amendment is futile. It should be denied. We still want it would make our motion for directed verdict possibly moot, but actually it wouldn't, because apparently, even though UNFW, again, is not here before this court, they apparently intend to preserve this claim somehow. So for all those reasons, the fact that the words Gold Coast never came out of any plaintiff's mouth during the trial testimony, and therefore the jury could not have returned a verdict, we think it's prejudicial now to allow this post-trial attempt to revive a claim that was abandoned by UNFW.
All right. Sir.
Good morning, Your Honor. Robert Schumacher for Real Water, Tennessee. In addition to the points that are included in our opposition, there are a few other things the court should consider ruling on this motion. Number one, the motion is procedurally flawed. Even assuming that the claims of plaintiff against Golden Coast were not waived, the correct mechanism procedurally would be a supplemental pleading pursuant to Rule 15P. But as to Real Water, Tennessee, those claims, as the court will recall, were adjudicated on motion for summary judgment. There was a dismissal with prejudice as to Plaintiff Belsky. There was a dismissal without prejudice as to Plaintiff Haley. And if there is an assignment, and let me digress, one of the challenges we had in opposing this motion is it's absolutely impossible to ascertain what the nature of the claims are in the proposed amended pleading. But assuming there has been an assignment, whether partial or whole, as it relates to the contract rights under the Food Product Service Agreement between UNFI, UNFW, and Real Water, Tennessee, there is a provision in the agreement that prohibits an assignment absent prior written consent signed by both UNFI and Real Water, Tennessee. There's nothing in the pleading that suggests that has occurred. I'm unaware of that having occurred. So the assignor, as the court knows, can only give what the assignor has. Do not create rights that don't exist through assignment. What rights did or does UNFW have?
There's no assignment with regard to Tennessee. I informed Mr. Kavanaugh that.
Well, it's unclear from the pleading. I mean, what Mr. Kemp said.
Here's my question. I mean, I do understand the impact of NRCP Rule 15. In fact, I think when we had this discussion a few days ago, and I can't remember exactly when the comment was made, but for example, and this was from the bench, I took a look at Rule 15 and I made a comment. Let me make sure I can find it here. Yeah, 15B, amendments during and after trial, and that's specifically provided for pursuant to the rules. And here's my point, and I don't know for sure where ultimately this will end up. Maybe there's prohibitions pursuant to some agreements. I don't know. But I'm looking at it through this lens. Number one, pursuant to 15B, it's permissible, right? It can be done. Secondly, if down the road there's some language pursuant to some contractual agreements between the parties, maybe that prohibits enforceability. I don't know that, right? You see where I'm going on that?
I understand your argument.
Yeah.
Judge, I don't think that's a problem because I told, go ahead.
We recognize that Nevada has a very firm policy, liberal amendment, we get that.
Right.
But as it pertains to real water Tennessee, the claims were adjudicated on motion for summary judgment. There is no basis in common law, statute, or otherwise for there to be an amendment to those pleadings. The only method procedurally that you would have done, you can pursue the claims that have been summarily adjudicated is as to Belsky, who was dismissed with prejudice via either a motion for reconsideration of the court's order granting the motion for summary judgment or a notice of appeal. That is it. There's no basis to transform the allegations and the claims that were in the pleading, the operative pleading at the time the court ruled on the motion for summary judgment. So, and similarly, as it relates to Haley, who was dismissed without prejudice, there is one condition, a single condition that this court imposed, and that is if, and this is a huge if the bankruptcy court makes a ruling that would change the effective date of the substantive consolidation back to the March date, which is the date of the redemption agreement, then this court said they can revive that claim, but as of right now, that condition has not occurred. So what if the court is inclined to grant the motion, it must do this. As it relates to Real Water Tennessee, the pleadings stand, and instead of the amendment, and Real Water Tennessee should be removed from, or any claims against Real Water Tennessee should be removed from the amended pleading, and a supplemental pleading should be done pursuant to 15D or an amended pleading that omits us. But the proper way, in my mind, Your Honor, is 15D supplemental pleading as it relates to Gold Coast, and the pleadings stand as they are. Otherwise, they are circumventing the court's ruling on the motions for summary judgment, because these claims are slightly different than those that were enumerated in the operative third-party complaint at the time of the motion for summary judgment.
They're not slightly different. They're word for word identical. And this Tennessee thing, they don't understand the procedural posture of the case, okay, obviously. Because what has happened is they filed a motion for summary judgment. We're filing a motion to amend to add in our claim on the assignment solely against Gold Coast. We aren't trying to add a claim against Tennessee. Okay, we didn't get an assignment of any proceeds from the Tennessee claim. But you have to re-plead it in an amended pleading. That's just black letter law, because if UNFW doesn't re-plead it, they abandon their rights on appeal. I don't know if they're going to appeal, but they're abandoning their rights on appeal if it's not repled. So that is the reason it has been repled, word for word identical. No one's trying to circumvent a summary judgment ruling. I don't know where he got that. You know, and if he wants to make a condition on this order that we're not trying to circumvent the summary judgment ruling, that is fine, okay? I've been very upfront with Mr. Kavanaugh that we did get an assignment. Been very upfront with him that we're not trying to revitalize the Tennessee claim. And then I hear this kind of garbage, you know? So Tennessee really has nothing to do with this, Your Honor. Absolutely nothing to do with this. The real issue is Real Water Gold Coast. And they didn't even make the argument they made before that they were confused. The reason that there are no issues of fact on the Real Water of Gold Coast claim in the first trial is Real Water Gold Coast wasn't a party to the first trial. If they had been a party to the first trial, I anticipate Mr. Neal would have presented the invoices to Mr. Belsky that say Real Water Gold Coast on them. That's just a fact. The invoices for his home delivery say Real Water Gold Coast on them. But this is not the summary judgment phase. If they had wanted to raise an issue of fact argument, they should have filed a motion for summary judgment, like Real Water Tennessee did. But they didn't do that, Your Honor. This is solely the motion to amend phase. So the pleading should be amended, and if they want to file a motion for summary judgment, fine, let them file a motion for summary judgment. Then we can argue about issues of fact. But right now, we're at the motion to amend phase. Leave should be freely given, and we should go forward.
Your Honor, briefly, for Real Water Tennessee, from a procedural perspective, if there's an amended pleading that asserts claims against it, post the court's ruling on the motions for summary
But he
judgment.
said he's not pursuing claims
Well, but there's
against
still
Real Water
amended
Tennessee.
pleading out there. What I'm saying, Your Honor, is there is a correct procedural mechanism for plaintiffs to do this. And you and
I don't think it
it's-
requires supplementation. I think a
Well, it's a
motion.
supplemental pleading under 15D. That
But
is the
there,
proper
what does he
mechanism.
want? I've told him we're not suing him. I've told him there's no assignment. I've told him he can have a condition on the order granting this if he wants.
What do
I
you
mean,
want?
You have to read.
I mean,
He just wants to eliminate the appeal now? I don't know what he wants.
No.
Okay?
Let me try to be real clear here. My concern is this, Your Honor, and it's a legitimate concern, and I don't mean to cast aspersion on any counsel. There's going to be an amended pleading out there that we will not respond to. It's improper. The correct mechanism would be for them to file a supplemental pleading against Gold Coast. That way, the issues as between UNFW and Real Water of Tennessee remain as they are with.
I'm going to cut this short because I have another jury coming, right? Then I have a jury after that, right? I'm just telling everybody this. And I look at it differently, and I think we're making a mountain out of a molehill as far as this is concerned, because we're seeking, it's my understanding the basis of this would be an assignment of an indemnity claim, right?
It's just proceeds.
Yeah.
We aren't even assigned a claim. We're just assigned to proceeds in the upper layers on this claim.
I understand where we're going.
But we are a real party in interest. That's
Yeah.
why we have to be in there.
And so, as far as all these other issues, they can be ferreted out. At the end of the day, this is the post-trial. 15 is pretty clear. If you take a look at amendments during or after trial under 15B, it can be done. And we've done a lot of litigation in this case, is my understanding. How many motions and did we have, pre-trial motions? 116, right? And the bottom line is this. I'm going to grant the motion as it currently sets. And if there's fallout, a law in motion, and we need clarity, I think it's important that if you want to bring issues up regarding some discrete potential problems, file a motion, and I'll hear that on
Judge,
the
I
phone.
think we're on the same page.
Yeah.
Tennessee anyway. They just don't understand we're on the same page.
Yeah, but and you can talk about it. But I'm granting a motion, and here's the thing: I don't have time to sit here and yeah, exactly. I have.
You know, we're not arguing motion for summary judgment. Here's the thing, Mr. Neal's not here. Well, Mr. Neal apparently still has his claims.
Well, didn't he assign his claims?
I don't know, I'm just reading it.
No, the issue here, Your Honor, is that they have to be replayed. Because
Well, I understand that, but here's the bottom line: any claims Mr. Neal might have had potentially wouldn't have been ripe for adjudication during the trial.
That's right.
Right, and here's my, well, sir, you can look inquisitively, but I've had many a construction defect case go to trial where those matters are handled in the third phase,
Sure.
based upon the finding of the trial court in the first phase. Correct, sir?
Yes, Your Honor.
Okay.
Your Honor, I'm not dis-
So I'm
not
trying to
disputing
figure out.
that. I'm not disputing that.
Mr. Schumacher, for 1 second, because for some reason. this is
No,
not
wait a second. I'm done. Next case.
Thank you, Your Honor.
We didn't have an issue with set off that you said we were going to talk about this morning.
A set off. If there's any set off issues, and you're right, that has not been waived for the record. Number one.
Thank you.
Number two.
She has it. I don't know how to do it because it is.
I think what he should do is write a letter to Mr. Neal asking him. I've been found by the company's Gallagher.
I agree.
So
Right.
I think he's entitled to it.
Yeah.
Okay.
He should just write a letter.
I didn't know how to handle it.
Everyone agrees, and it's not been waived. It's in the minutes. Set off has not been waived.
Thank you. That's all I need then at this point.
Yes.
One other matter that appears on calendar, I just want to make sure we've handled everything. There's something about Uniform Commercial Code, NRS 104. I don't know what
Is that on
is.
calendar?
It says the Gallagher case. It's not mine.
It might
That was
be
Rob's case, that was Rob's.
Rob.
argument? I thought he lost already, Your Honor.
Okay. Well,
So I just want to make sure we handle all our business.
Yeah, it
Can I
definitely
ask a question
indemnity.
of clarification, please?
yes, sir.
Is Real Water Tennessee supposed to answer this amended?
No,
third-party
I don't
complaint?
think so. They've
You
been,
wouldn't answer until you serve with, right?
Yeah,
That's number one. Number two, do you represent Gold Coast as well as?
You're stipulating we're no longer involved in the.
There's no problem here, okay?
Well, Mr. Neal's not here. All right.
Thank you, Your Honor. I guess we'll go outside in the hall and wrestle.
work it out.